Good morning to all of you. Once again, ethics class, question number 18. This is the last question. So, the brief facts of the question are like this. The client entrusted two cases to the advocate. The client entrusted two cases to the advocate. The advocate filed one case before the court, but he did not file the other case. Then what happens? Will it be taken as a professional in conduct or not? He did not file the other case. Discuss. So, please remember once again, ethics. So, in 2022, all the questions are on only ethics, not on the contempt. And the two Bar Council rules. So, I told you extensively the Bar Council of India rules, chapter 2, part 6, that is from 1 to 52. They are most important. With this reason, we can say that you have to read the rules well. Of course, you may not be able to remember the rule number, but at least you must say, according to the BCI rules, it is stated like this. Unless I put no problem. So here, the important point is discussion. Whether the advocate can file one case and can leave the other case. Suppose what if it is a promissory note case? What happens if the limitation period is gone? According to section 9 of the Limitation Act, once the period starts running, it will continue to run and it will stop after 3 years. So after 3 years, you can't do anything, is it not? So in such a case, please remember, it is misconduct on the part of the advocate. Therefore, I told you rule number 11. You should take up cases where you are practicing or propose to practice. Once you take up the case, definitely you have to attend the court on all disappearing. It is not here. The point is not attending the court. Filing the case. Yes, you have to file the case. You have to file both cases. You can't say I have filed one case and I left other case. So, and please remember, Rule 15 also is important. Rule 15 says the advocate should uphold the interest of the client. Yes, what is the interest? His interest is to file the case. If you don't file the case, you are not upholding his interest. Rule 15 is also violated. Number of cases are there. Very famous cases, VCRangadurai Vs D.Gopaln 1978 case. VCRangadurai was a very famous advocate in Madras. So this D.Gopaln Devasenapati, somebody, D.Gopaln, Gopalan Devasenapati something. So this man is aged about 70 years, senior citizen. So he, along with his wife, consulted VCRangadurai and asked him to file 3 cases of pro-note cases. 3, you may be knowing. These people, they moved around the other party, they did not pay back the money. Therefore, they came and requested the advocate to file the cases because the limitation period is going away. Then immediately VCRangadurai accepted. He asked the junior lawyer to file the case. But they don't know, they did not know whether he filed the case or not. They wanted to meet Rangadurai, but whenever they come, these junior lawyers, they said, we are looking into the matter, why are you going to consult? Our senior advocate is very busy, like that. On one occasion, they saw Rangadurai speaking to the opposite party. So then they got a doubt. They got a doubt whether he is favoring us or whether he is favoring that man. Actually, Rangadurai was speaking to them in a criminal case, not in this pro-note case. So ultimately, Rangadurai did not file the case. So when the matter was taken as a professional misconduct, it has to be accepted. He was suspended for 6 years from practice. So don't do that wrong thing, even though he doesn't give you the money. You have to file the case, then you can collect the money. Second case, State Bank of India, DP, his name is Dalal DS. Dalal DS versus State Bank of India, 1993. Actually, Dalal sir was a practicing advocate and he was a legal consultant to the State Bank of India. They have entrusted number of cases to him. Whenever anybody files a case against State Bank of India, they used to, actually panel of advocates will be there. They have given a lot of cases. But they came to know that he did not file some cases. He has misoperated money, the amount of fee in some other cases and things like that. Ultimately, they wanted to terminate his services. So please remember, the SBI entrusted number of cases and paid fees also. But in some cases, he filed and some cases he did not. And moreover, he used to say that the record are missing in the High Court. So it is learned that it is established that in the High Court the record has not gone. He has not filed the case. So this is what. So ultimately he was held for professional misconduct. And another case is there, that is a negative example. So this is VP Kumaravelu versus Bar Council of India 1997. So VP Kumaravelu, he was a practicing advocate, and actually he was posted as a city government pleader in Madras. City, at that time there were 6 courts, civil courts. He has to represent all these cases, all the civil courts. He has to move around all the 6 civil courts. Therefore, he could not concentrate and he could not file the written statements. He could not represent the court in some cases. As a result of which, the government, Tamil Nadu, they have to pay a lot of money to Mettur Mills and some other case also. So anyway, it was taken as a professional misconduct, and he was tackled by the Bar Council of India. But when the matter has come before the Supreme Court said it is not a professional misconduct. It is only, you can take it after all a negligence, because this Kumaravelu proved that he was not given any support staff, and he has to move around the courts, and there is no enough time. He was only government pleader, no assistant government pleader was there. Like that he explained. Of course, Supreme Court was satisfied that it is only negligence, but it is not misconduct. So negative example. So with these 3 examples, I think you are by now clear. An advocate, when he takes up a case of a party, he has to file the case. He has to attend the court. So if he fails in any one of these aspects, it definitely amounts to professional misconduct, and he can be dealt with that by the disciplinary committee under Section 35 of the Advocates Act, and he can be punished or can be let loose. So that's all. I think by 2002 examination papers also are completed. So please read the case laws carefully and try to answer in the examination. Wish you all the best. With this, I am concluding. Thank you very much.